Lopez. He is our keynote, and we are so honored and privileged to have him here. I want to welcome to the stage Jeffrey Deskovic.
Good evening. Good evening.
Good evening.
Let's do that again. Good evening.
Good evening.
One more time. Good evening.
Good evening.
Thanks for coming out tonight.
Thank you.
In 1989, a classmate of mine was found murdered and raped. Peekskill was a small town with a population of approximately 20,000 people. Murders were very rare. So when this murder happened, it understandably it created an atmosphere of fear, of rumor, of paranoia. Parents were concerned with their own safety as well as the safety of their children. In high school, I was quiet. I was to myself. I didn't participate in very many organized sports. This made me seem strange to some of the kids in the school. In the course of the police investigation, they interviewed many students from that school. Some of those teenagers told the police that they might want to talk to me because I seemed strange to them. This is what the police said initially attracted them to me. The other factor which they said attracted them to me was that they claimed that I was overly upset at the victim having been murdered. Yet there were mental health facilities set up all throughout the town of Peekskill to help people process what had happened, again keeping in mind that murders were very rare. They reached a point in the police investigation that they asked me to take a lie detector test. I agreed to take the test. And so the next day, rather than report to school, I instead went to the police station. As I just mentioned, it was a school day, which meant that neither my mother nor my grandmother with whom I lived realized that anything was wrong, and hence they did not call around looking for me. They drove me to the town of Brewster, which was in Putnam County in New York. I was a native of Peekskill, which was in Westchester County, New York. The significance of my sharing that with you is that meant I was no longer able to leave on my own. I was instead dependent upon the police. They put me in a small room. I did not have an attorney present. I wasn't given anything to eat the entire time that I was there. They played the game known as good cop, bad cop, in which one officer takes a more aggressive role, while the other pretends to be a friend who's opposed to what's happening, yet is somehow powerless to intervene. The purpose of this tactic is that when a person's being questioned, when you become fearful, it's only natural that you look to a friendly face for support. The polygraphist himself was actually a Putnam County Sheriff's investigator, pretending to be a civilian, hiding the fact from me that he was, in fact, a police officer. They attached me to a polygraph machine. Now, before commencing the test, the polygrapher gave me countless cups of coffee. And the reason why that's important is because the premise of the polygraph is that when a person tells a lie, you'll become nervous. The nervousness will result in the pulse rate being sped up. And in fact, it is the pulse rate which is measured by the machine. Other factors, however, which will lead to the pulse rate being sped up would include fear and caffeine. They used all kind of scare tactics on me. The polygraphist invaded my personal space. He raised his voice at me. He kept asking me the same questions over and over again. As each hour passed, so too did my fear increase in proportion to the time. Towards the end of the interrogation, the polygraphist made a statement to me. He said, "What do you mean you didn't do it? You just told me through the test that you did. We just want you to verbally confirm this." When he said that to me, that really shot my fear through the roof. At that point, who should make his grand appearance other than the police officer who was pretending to be my friend? He informed me that the other officers were going to harm me, but that he was holding them off, but could not do so indefinitely. "You have to help yourself here, you understand." Considering I had maintained my innocence for the previous 7.5 hours, it was clear what he meant by that. They wanted me to confess. When it was added that if I did as they wanted, not only would they stop what they were doing, but that I could go home afterwards. Being young, naive, frightened, 16 years old, not thinking about the long-term implications, instead being concerned with my own safety, right then myself and the police, I took the out which they offered, and they made up a story based upon information which they had given me in the course of their interrogation. By the police officer's own testimony, by the end of the interrogation, I was on the floor in the fetal position, crying uncontrollably. Needless to say, I was arrested. I was in fact charged with murder and rape. Now, before I went to trial, the results of the DNA test came in from the FBI lab. Semen found in the victim did not match. But rather than acknowledge they made a mistake, they instead continued to prosecute full speed ahead. In order to explain away the exculpatory DNA test, the prosecutor elicited fraud on the part of the medical examiner. When a medical examiner makes his findings, there are audio as well as written notes which are making contemporaneously as the findings are made. It was only 6 months after doing that initial autopsy, and only after the DNA didn't match, that suddenly, for the first time, the medical examiner claimed that he found medical evidence to show that the victim, a 15-year-old immigrant from Colombia, in the country for a mere year and a half, leading a very sheltered life in which she never went outside, save accompanied by her parents or her older sister, that he found the evidence that showed that she was sexually active. That's what enabled the prosecutor to make that argument. He even went so far as to name the other youth that supposedly had this encounter with her. Yet, they never performed a DNA test in order to prove it, nor did they even call this other youth as a witness to give verbal testimony to that effect. He just made the unsupported argument to the jury. At the same time, the public defender that I had was not very good. Here are some of the things that he failed to do and things that he should have done. Firstly, when the medical examiner, who was playing this unusually important role in my case, when it was time for cross-examination, my lawyer stood up in open court and, with a big smile on his face, as if him and the medical examiner were old friends from way back in the day, said, "You're going to be pleased to know that I don't have a single question for you." He never investigated my alibi witness, nor even called him to give testimony. At the time that the crime happened, I was in fact playing wiffle ball. When the fraud was committed by the medical examiner and this other youth's name was used, my attorney was supposed to investigate this false theory and just generally explode that myth. Yet he never did, because that youth was represented by another member of the public defender's office who was representing me. So that conflict of interest hindered the defense. Not only was it just any public defender, but in fact it was his supervisor who was supposed to be answering questions that he had as he represented me. My lawyer never explained to the jury the significance of the DNA excluding me, nor did he use the DNA to argue that the so-called confession was coerced and false. When we hadn't decided if we were going to have a jury trial or a bench trial, the trial judge came to my attorney off the record and told him, "Pick a jury, because I don't want to be responsible for finding your client not guilty." Yet my lawyer never put that on the record as a basis to ask the judge to recuse himself. To me, that statement that the judge made indicates bias, and also that public pressure must have been getting to him. Add it all up, I guess it's not that surprising that the jury found me guilty. I'll never forget the day that I was found guilty, because to me it was like some sort of nightmarish alternative reality, because to my way of thinking, at least up until that point in time, only guilty people were actually convicted. Yet they said what they did, and I was taken into custody. On the day of the sentencing, I begged the judge to overturn the verdict, because I was innocent, and I referenced the DNA to support my contention. He actually told me on the record, "Maybe you are innocent." That didn't lead him to step up for justice and exercise his discretion by overturning the conviction. Instead, he took the politically expedient way out and sentenced me to a term of imprisonment of 15 to life. I would like to share with you a little bit about my prison experience. I still remember the first day. I remember having on handcuffs and a chain around my waist and my legs being fastened together, as well as being fastened on the bus to the prisoner sitting next to me. I remember how large the prison walls loomed and how frightening the barbed wire appeared. I don't mind sharing with you that it was a very scary experience. As I walked down the cell gallery, I saw many prisoners there whose arms were as big as my legs. It didn't take a lot of figuring out on my part that if any of them decided to assault me, that I would not be able to protect myself. I also had the built-in handicap of knowing that if they discovered what I was incarcerated for, which was a rape along with that murder, that this would serve as motivation on their part, to assault me, because in prison there's a vigilante mentality towards people who have been convicted of sex offenses. The guards themselves were obstacles. To be sure, some were professional and did their job. Yet there were others who came to work and brought the problems from their personal life into the facility, displacing it onto the prisoners. Then there were other guards who even their peers disliked because it made it likely that prisoner to staff violence could occur. Yet nobody ever bothered to reel them in, not their co-workers, nor the people who supposedly were there to supervise them. Then there were guards who just wanted to do their 8 hours and go home, and they didn't care what happened while they were there. While that might sound like an ideal attitude that you'd want a guard to have if you had to be incarcerated, it didn't actually work out that way in real life, because it would not be unusual for them to literally look the other way and walk in the opposite direction when violence was occurring, so as to be able to avoid breaking things up and filing paperwork afterwards. There was a system of maintaining order in the prison known as keep lock, which involved a variety of sanctions being imposed on the prisoners if they were found guilty of having broken a prison rule. Some of those conditions included, but were not limited to, being kept in the cell 23 hours a day out of the 24. They would send you less food. Sometimes the food they would send you would be 3 or 4 days old. Their idea of complying with the court-mandated 1 hour a day recreation consisted of putting the prisoners in a small caged area with maybe a pull-up bar in it, if you were lucky. You would be able to take 2 showers one week and 3 the next, rather than being able to shower daily as the rest of the population. You would not be able to use the phone while you were on such status. In the facility in which I spent 13 and a half of the 16 years, Elmira, it was particularly violent there. There were 3 or 4 stabbings or cuttings every day, no shortage of violence that didn't involve weapons, and there was plenty of gang activity. Taken together, there was a general atmosphere of violence and adrenaline that permeated the air. There were several times in the course of my incarceration that I was assaulted, and one time in which I nearly lost my life. In addition to dealing with the physicality of that, I was subjected to those sanctions that I just explained, because in prison, if you were defending yourself, then you were fighting. While I was in prison, I tried to minimize the loss that I was experiencing. I obtained a GED, and I got an associate's degree, and I completed a year of schooling towards a bachelor's. But then even this silver lining was taken from me, because in 1995 in New York, George Pataki became governor, and he decided it would be a good idea to cut the funding of college education for prisoners. He did that on the state level, and Senator Helms did it on the federal level. It was like a chain reaction throughout the country, where the colleges really left the prisons. When that happened, I looked to the vocational trades to try to do something positive with my time. But although I amassed many certificates, it looks much better on paper than what it actually is in reality, because the material was obsolete 5 years prior to my ever having stepped foot into the shops. I remember the pay grades that they gave the prisoners there for their assignments, whether that was educational, vocational, or in one way or another related to the running of the prison. I remember they paid 16, 22, 25, 32 cents an hour. There were a limited number of positions that paid 38 cents an hour, and there were 4 precious 42-cent an hour positions. Out of that money, the prisoners were expected to purchase items that were not given to them by the state, such as shampoo, deodorant, postage, pens, paper. And if miraculously there was somehow something left over after that, that would be important, because there were some limited food items which could be purchased at the commissary. Because in general, the food in the prison was not very good. Sometimes the food would be burned, at other times it wouldn't be fully cooked, while at still others there was problems in terms of the portion amount, while other items found their way onto the menu 4 or 5 times a week. In In 1996, the prison told me that they received information from the hospital that my grandmother was extremely sick and in the hospital and she was not expected to survive. And so I had a choice. Did I want to wait until she passed away and then go to the funeral service, or did I instead want to see her while she was alive, yet in a coma? Now, at that point, I had been incarcerated for 5-6 years already. I had already lost a few appeals, and I was serving a life sentence. And I knew that there were many members of my extended family that had never come to see me in the prison, and who, in fact, would never come to see me while I was incarcerated. So waiting until my grandmother passed and going to the funeral service represented the last clear opportunity I would have to see those members. As you might imagine, it was a very difficult position to be in. I mean, would it really kill them to allow me to go to both? Yet, that wasn't how the system worked, and I had to make a choice. In the end, I decided to see her while she was alive, yet in a coma. We left Elmira early in the morning prior to the population being served breakfast. The guards were given funds with which to purchase food items for themselves and for me. But although they got something to eat, I was merely provided with a cup of coffee. Because of the fact that I've always suffered from motion sickness, there were several times, and I hadn't been given anything to eat, there were several times that they had to stop the car and pull over because I was on the verge of vomiting. Yet, because nothing was in, nothing came out. I guess I was lucky in that sense because I had on handcuffs and I had a chain around my waist, and even though there were two guards and they both had sidearms and a shotgun, and surely I posed no threat to them in that position, they were unwilling to loosen the handcuffs even a little bit. So had I gotten any vomit on my clothes or on my face, I wouldn't have been able to wipe it off. When we arrived in Peekskill, 3.5 to 4.5 hours away, they parked the car as far away from the hospital doors as they possibly could, so as to be able to parade me through the parking lot. Again, keeping in mind that I had on handcuffs and I had a chain around my waist and I had my legs fastened together. I remember there was a nurse attendant who was on duty who did a double take at the sight of me. And there was a child who was probably around 5 or 6 years old, and she was running around playing. When the mother got a sight of me, she grabbed the child and brought her close to her as if I was some kind of violent animal that was going to commit a spontaneous act of violence right there on the spot. It was definitely a humiliating situation. When it was time to go, the guards came in the room and informed me that my hour was up, but I saw on the clock that in fact it had only been 45 minutes. But they insisted it had been an hour, and they forced me to leave. Again, parading me through the hospital corridors and the parking lot. This time on the way back, I was allowed to have something to eat. But by this time, 45 minutes later, the parking spot which the vehicle had been sitting at, it lent itself to sunlight kind of beaming through the windshield, and so by now the vehicle had become quite hot. Although the guards turned on the air conditioning in the car, none of it reached me because there was plexiglass fully separating the front of the vehicle from the back, and they were unwilling to lower the windows even a fraction of an inch. All told, I suffered for about 7 to 8 hours in order to visit with my grandmother for less than 1 hour. Towards the end of my sentence minimum, the prison authorities told me that if I wanted to have any shot at all of making parole, which was already a slimmer than slim possibility as it was, that I would have to take and complete the sex offender training program. The problem with taking that program, however, was that there was an explicit guilt admission requirement. I would have to admit guilt, not simply to the instructor, but also to the other prisoners in the class with me. They would not accept it if I simply said that I was guilty, but they wanted me to give details. A verbal rendition would not suffice. It would have to be done in writing. Failure on my part or anyone else's part to comply with any of those aspects would have resulted in the immediate removal from that program, and I would have been deemed to have refused to complete it. So once again, I was in a very difficult position, and certainly I was looking at parole as a potential means of regaining my freedom, and clearly I wanted to do that before anyone else in my family passed away. After a lot of soul searching, I decided that I would not take the program. I couldn't bring myself to give details about a crime that I did not commit. When I went to the parole board hearing I knew that the parole board was in the habit of rubber stamp denying parole applications, even from applicants who could demonstrate that they had turned their lives around and would, if released, not pose a threat to society and hence would not get arrested. So in order to try to protect myself from having that happen to me, I kept raising the issue of my innocence and citing the DNA. But they were unwilling to consider even the mere possibility that I was innocent. Towards the end of the interview, one of the commissioners asked me a question about an aggression replacement training program that I had taken, and I was able to give them the answer, demonstrating that I had learned the material in the class. That's when another commissioner piped up and said, "Well, that's good, Mr. Deskovic, because you're going to need those skills once you return back to society. Good luck." Now, the procedure is that they don't inform you of their decision on the spot. They instead send it to you via institutional mail 3 days later. Considering how the interview ended, I actually walked around the prison for the next 3 days thinking that I had somehow defied the odds and that I would be going home. When I got the decision in the mail, it noted that I had a good disciplinary record, that I had an excellent educational record, that I had a few letters of support, that I even had a prison employee recommending that I be released on parole. Yet, nonetheless, I was convicted of a brutal and senseless crime, and to release me would be to deprecate its seriousness. They turned me down and ordered me to reappear in front of them 2 years later. Now, considering I knew many prisoners there who were working on years 25 and 30 off of a 15 to life sentence in which they would go to the parole board, get turned down, reappear, get turned down again, and kind of have that cycle continue in perpetuity. It was at that moment that I thought that I was going to die in prison. I would like to share with you how it was that I came to be cleared. While all this was happening, and a lot more than I'm skipping over just for the sake of time, I was simultaneously appealing my case throughout the court system. I went to the appellate division, the first court one must go to. My primary issues on appeal were my innocence as demonstrated by the DNA and that my Fifth Amendment rights had been violated. The court found nothing wrong with the way I had been questioned, and furthermore, they ruled that there was overwhelming evidence of guilt, which made no sense because the forensics were in my behalf. There was no physical evidence. They ruled against me 5-0. My lawyer moved to re-argue the case, arguing that their decision was running contrary to the facts and to the law, but the re-argument motion was denied. I then went to the Court of Appeals, New York State's highest court. The procedure is that you have to obtain permission for them to appeal before they will agree to let you argue the issues. The Court of Appeals told me that there was no merit in law to justify reviewing my case, and therefore they were declining to review it. I then looked to the federal court for relief. I filed what's known as a petition for writ of habeas corpus, which is when a state prisoner is arguing that his or her conviction is running against the United States Constitution. Again, my primary issues in that petition were my innocence and also my Fifth Amendment rights. Now, at that time, there was confusion in the federal court system because 1 year prior, Congress had passed and the President had signed into law the Anti-Terrorism and Effective Death Penalty Act, which in relative part stated that all state prisoners would have 1 year to file in federal court after being denied by their state's highest court. The confusion with this new ruling was centered around how would this apply to cases that were already in the system, and different jurisdictions were answering the question in different ways. So my attorney contacted the court clerk and asked for clarification. Would it be enough that my petition be postmarked on the due date, or did it have to be physically filed and in the building on the due date? The court clerk told my attorney that it would be enough if it simply be postmarked. Well, unfortunately, that turned out to be inaccurate, and as a result of that, my petition arrived 4 days too late. Former Westchester County District Attorney Janine Pirro and New York State Attorney General candidate, her office took the position that those 4 days were somehow prejudicial to the people, and therefore the court should simply rule that I was late without even looking at my innocence argument supported by the DNA. And that meant I was time barred, meaning I no longer would be able to argue my issues directly. I was instead relegated to arguing that the procedural ruling against me was inaccurate in order to have that reversed, to then go back to the lower federal court, to then have my issues argued directly. So I went to the United States Court of Appeals, and much like the State Court of Appeals, you had to obtain permission to appeal to them. I was granted permission and my attorneys advanced 3 arguments as to why the procedural ruling should be reversed. Firstly, that this was not a delay caused either by my attorneys or by me, but in fact by misinformation by the court clerk. The second argument was that to allow a ruling like that to stand would be to cause a miscarriage of justice to continue, which kind of backdoors the innocence argument back into the case, at least as a contextual issue. And thirdly, that reversing the procedural ruling would open the door to more sophisticated DNA testing of the type which would go on to clear me 7 years later. Now, one of those two judges who was deciding this issue here would go on to become United States Supreme Court Justice Sonia Sotomayor. Once again, the district attorney opposed, and once again, the court sided with the district attorney. My lawyer moved to re-argue the case in front of them, in fact, requesting that all the judges on the circuit hear and rule on the case. That's how strongly she felt about it. But the re-argument motion was denied. That meant we had one court left to go to, the United States Supreme Court. Nationwide, that court agrees to hear only between 2 to 5% of all matters that come in front of it. And included within that small figure was a certain amount of civil matters. So we knew going in that despite compelling reasons of justice as to why they should do so, the odds of them agreeing to do so were slim. Having no other court left to go to, I had no choice but to forge ahead. I was not able to overcome the odds. As expected, the United States Supreme Court declined to give me permission to appeal to them. That marked the end of my appeals and the end of legal representation. That was in 2001. The path, therefore, to overturn my conviction and therefore to regain my freedom would be that I would first have to somehow obtain an attorney who would take my case for free, for neither I nor my family had the funds with which to hire one. Then hope that we could find an investigator willing to work on a similar basis. And then hope that in collaboration they could somehow find some additional unknown evidence of innocence, without which the court was no longer willing to hear from me. So my legal work, if you really want to consider it that, consisted of writing SOS type letters to anyone and everyone I could possibly think of who could help me, either directly or indirectly. I wrote large law firms because I had read that such firms often have a pro bono section in it, which they would take cases for free. I very rarely heard back from them. When I would hear back from them, they would tell me that they had no time to take my case for free, although they always made sure that they never closed out their letter without telling me how much money they wanted, should I somehow be able to scrape it together. Reading between the lines, I guess what they were saying was that if I had the money, then they would have the time. Then they would end their letter by saying, good luck, as if I'd be okay despite their non-intervention. I wrote reporters, especially those who had written on other wrongful conviction cases or issues, reasoning that their general familiarity with the subject matter would put them in a better position to understand what I was saying, and maybe they would dig around and write an article or two, and therefore my case would get the writing a book author in care of a publishing company. The author had written a book for her memoirs from when she was a warden of a men's maximum security prison in California. But she never got the letter. Somebody at the publishing company opened the letter, read it, and instead sent it to an investigator who works out of Colorado and Maine. She wrote me back right away. We brainstormed together, she gave me ideas, and she attempted to get people to take my case. One of the ideas she gave me was that I should write the Innocence Project again, a not-for-profit organization in Manhattan that works to clear prisoners in cases across the country in which DNA testing can demonstrate innocence and in which no prior testing has been conducted. The problem that I encountered on my first go-around attempting to get their assistance in 1992-93 was that prior testing had been conducted. The results didn't match me, but I nonetheless had been convicted, and they never saw a case in which that had happened. Therefore, they told me there was nothing else they could do. Fast forwarding back to 2005, the investigator told me that with the advances in DNA testing and technology, that the prior denial was irrelevant, and so I should write them again. Now, I didn't want to do that because I thought that I would get a similar response to what I got the first time around. But having very few other options, I had no choice, and so I did so anyway. And then I forgot about it. I continued to look for other methods by which to obtain representation, none of which were successful. 6 months later, seemingly out of the blue, the Innocence Project contacted me, and they informed me that they were going to take my case. By this time, Ms. Pirro had left office, and her predecessor had been there for a mere 40 days. And they prevailed upon her, and she agreed to voluntarily allow me to have more sophisticated DNA testing. The results matched that of a man who left free while I did time for his crime, killed another victim 3.5 years later, a school teacher and mother of two. In September 20th, 2006, my conviction was overturned and I was released. I reported back to court November 2nd, 2006, at which point all the charges against me were dismissed on the grounds of actual innocence, and my innocence was acknowledged by the prosecutor and the judge, although neither of them were their counterparts who originally had anything to do with my initial wrongful conviction. At that point, I was completely free to somehow start my life over again with very few possessions beyond the clothes that I had on. I would like to share with you a little bit about my life post-exoneration. The world is much different now than what it was when I was originally convicted. To give some concrete examples, we didn't have cell phones, internet, GPS, the sophisticated methods of banking that we use. As I walk down cities and towns that I once knew, although some of the buildings and houses and businesses remain the same, yet others have disappeared and have been replaced with newer things. The people who I once knew, who occupied those cities and towns, have long since moved away. And so I get this eerie feeling that comes over me often, that I'm still in some sort of alternative parallel universe. When I visit with members of my extended family, it's an awkward and uncomfortable thing, because even though I know who they are intellectually, having memories of them from when I was younger, yet when you spend large amounts of time away from them, you grow apart. And so there's a communication gap, and it's hard to relate and understand them, as I'm sure it's hard for them to relate to and understand me. I received a scholarship from Mercy College, and I completed the bachelor's, and as Helen mentioned earlier, I just completed the coursework for a master's degree. I've done a lot of work as an advocate individually. I've spoken throughout the country, and I was a columnist for 5 years for a weekly newspaper, and I lobbied elected officials in New York and Connecticut, and I weighed in when legislation was considered on lawful conviction prevention measures, as well as issues around capital punishment, with the obvious risk of executing an innocent person being one of the main issues there. I want to share a little bit about my foundation beyond what's already been shared with you. I formed the foundation for a few reasons, non-DNA cases. We have 4 full-time staff members, including an attorney, an investigator, and a case coordinator. Then we have the reintegrative side of things, in which we acknowledge that it's not enough to simply free people, but we have to help them to rebuild their life after they've been released following a traumatic experience, such as being wrongfully incarcerated. So we've leased an apartment. We have a pair of exonerees living who didn't have another place to stay at. We provide them with regular contact emergency funds, and we're looking to not only sustain what we have, but also to grow it, to expand the capacity, the amount of cases that we're able to work on. Now, before I get into the similarities of cases between myself and Kirstin's case, I think it's important, just as a little bit of contextual information, that we understand what some of the systemic deficiencies are that lead to wrongful convictions. The criminal justice system, as it is currently constructed, is broken, and there's many cracks in which innocent people can fall through in order so that they wind up wrongfully imprisoned. And there are reforms that can shore up those cracks. And so in no particular order, I'll touch on lightly just a few of them. We need to videotape interrogations from beginning to end so that it can be a complete and accurate record of who said what, when, and in what context. It will prevent police officers from leaving details out of their testimony, while also protecting honest cops from false allegations of coercion. False confessions, you might be surprised to know, is the cause of wrongful convictions in 25% of the 306 DNA-proven wrongful conviction cases throughout the country. Although adults have been known to give coerced false confessions, particularly vulnerable populations would include people with mental health issues and youth. We need to have better identification procedures because misidentification has been the cause of wrongful convictions in 75% of the cases. We need to have safety protocols when it comes to incentivized witnessing, which is when people receive benefits in exchange for testimony, for that's been the cause of wrongful convictions in 15% of the cases. Some of the safety protocols there would include a mandatory external evidence corroboration, so that it wouldn't be enough for somebody to simply come in court and getting a benefit for testimony and pointing the finger. And the reason why that's important is because when someone is caught red-handed and does not have truthful testimony to trade on, they will falsely incriminate other people. Another reform in this area would also be, wearing a wire and recording these dubious jailhouse confessions in which people who know each other for a mere matter of weeks or months freely talk about committing murders, rapes, robberies, and other serious felonies which carry substantial prison terms to it. So we can be sure that these conversations take place rather than our fabrications. We need to have a standardized evidence preservation system. For right now, there's, in most states across the country, there's no law mandating that the government preserve evidence. So if you're lucky enough to be wrongfully convicted in a case that does have DNA in it to test, the first hoop you have to jump through is whether or not the evidence has been lost or destroyed. If either of those things have happened, you simply would be stuck in prison, unable to prove your innocence. We need to have a better system of public defense. It's not unusual for public defenders to represent 100 or more cases simultaneously. We need to have an equal playing field of financial resources and manpower so that there's a balance between the prosecutor's office and the public defender's office. We need to have equal pay for both sides so that the best legal talent doesn't go to one side or into public or into private practice. We need to have one centralized system which would enable there to be oversight, quality control, so that those who've been found to have rendered ineffective assistance to counsel would not be in position to do so again. We need to criminalize clear-cut, intentional prosecutorial misconduct. To me, when a prosecutor engages in conduct such as withholding exculpatory material or evidence, suborning perjury, not correcting perjured testimony, working hand in glove with experts, tell me what you want to prove and I'll prove it, rather than allowing the experts to give ground-level truth as an objective scientist. To me, such a person is breaking the law and is using the legal system to pull off a kidnapping under color of law, and there should be a criminal penalty to punish those who would do that and to deter others who might otherwise be tempted. For prosecutorial misconduct is rampant throughout the country. Many studies have shown that it's pervasive throughout the system, and that the system cannot, as it currently stands now, police itself. Similarly, we have the doctrine of prosecutorial immunity, in which no matter how egregious the misconduct that a prosecutor engages in, they cannot be sued individually, and as the U.S. Supreme Court recently severely limited the ability to sue the office as a whole. There's no other aspect of law enforcement. It's not police, not experts, not correction officers. No other part of the system, has this immunity, and yet they're not hindered from doing their jobs. So the idea that we need prosecutors to have immunity so that they're not afraid to do their jobs, that they can focus on prosecuting criminals as opposed to defending lawsuits, is all hogwash. If you don't want to be sued, don't run over someone's rights, don't engage in misconduct, don't engage in prosecutorial misconduct, don't wrongfully convict people for crimes that they're innocent of. You know, this is all about, these reforms, this is not about being soft on crime, it's not about coddling criminals. We're talking about accuracy here. We're talking about arming law enforcement to the teeth so that they can make accurate arrests, have accurate outcomes. This is a public safety issue because not only when you send the wrong person away, you send them as well as their family, but you more, well, you can't really say more. Conviction remains in place despite a negative DNA testing. We both have sought to have further testing, only to be rebuffed. The testing we sought involves more sophisticated technology than originally in place. Both cases involve police misconduct. In my case, this was not a good faith error. This was because the bottom drops out of that argument when you think about that once the DNA didn't match, they should have dropped the case and said they kept going. It was misconduct in this case, as already has been outlined by prior speakers, so I won't reiterate. I want to make an appeal to the current district attorney to allow more sophisticated testing. Either it's going to prove guilt, in which litigation can end, the specter of innocence disappears, or it'll prove innocence, which will enable an innocent person to regain their freedom, go on with their life as best they can, while providing investigative avenues for the actual perpetrator to be apprehended, or at least to have a conclusion. If the actual perpetrator is not alive any longer, at least we can have the conclusion. But the investigation needs to continue so that we can be sure that there's not another murderer on the loose. DNA testing is critical. It's absolutely critical to accurate judgments. Thank you very much. So before opening for question, I have a brief statement to make. I would just like to acknowledge in the audience the